right, let's see, we hit the buttons, we did the stuff. It looks like we're connected. All right, cool. So happy Friday. Hope you guys are doing great. Hopefully you've checked everything off of your list to do for the weekend. You're ready to like check out and have a great weekend. So anyway, we got a couple things to cover today that I thought were fairly interesting and people would probably want to know about. So we're kind of in this weird phase of they're still arguing about discovery, and we're months into this discovery process now. And I got the transcripts from the judge. Thankfully, somebody posted it on there. So in the docket. So we have that, and we're gonna go through it. And you guys let me know. It seems weird to me because I don't understand the judge's argument on a lot of this stuff in where he's coming in. He's kind of like picking both sides. Anyway, we'll get to it. So we'll talk a little bit about that, and then we have the arguments around discovery that's happening. So basically in this process of GFI still having agents potentially with WFG and them still moving people over. And I also got an update on what the actual licensed agents are, so we'll talk to that closer to the end when we look at the judges stuff. Maybe it's not as big of a thing as I thought it was. Maybe it's not actually the 14,000 agents. It seems to be quite a bit less than that if we talk about licensed agents, so I think I have an updated number on that. But anyway, there's two things that are kind of happening. One, they're not really giving the discovery stuff that they need. So we talked about this previously, but there's like the preparing for the bank robbery, then there's the actual days of the robbery, and then there's what happens after that, and then there's Eric's termination on the 22nd of January. And they're only really turning over discovery stuff from after the termination. It's like, okay, well, that doesn't really make sense. If there's stuff that's happening, wouldn't we want to know about it? And the judge isn't really going on with that. So then the other side of that is, okay, they're getting documents after Eric's termination, which are showing things are still happening inside of WFG. And then the judge is allowing them to classify these documents as attorney's eyes only. So imagine you guys are financial professionals. Imagine you go into one of your client's accounts and you can tell that somebody's stealing money out of that account and you're not allowed to tell the client. That would be really weird, right? So the judge is basically saying it's okay that GFI is raiding from WFG, and WFG isn't allowed to know who the people are in WFG that are still doing it, because we need to protect them that they can't be retaliated against. So it's really kind of strange to me. Read it with me so that maybe you guys can make it make sense to me, because I can't put it together. I don't understand why it makes sense. And so those two things combined, they're basically able to just cloak everything that's still going on. I don't know. I don't know how the judge doesn't see that being part of the problem. So anyway, let's get into it, and you guys can tell me what you think about it, because it seems really strange to me. I can't put my finger on it. So let's start off. We're going to go through kind of the complaints that WFG is having. We'll talk a little bit about GFI's complaints and what's going on there. And then we'll talk about what the judge actually said in his transcript. So I'm going to skip some of this stuff kind of in the beginning, but basically they are arguing over expedited discovery. And the reason why this is so important is because it's the information that we're actually going to get about what's going on. So it was granted on February 26th. However, WFG asked for expedited discovery, I think it was on the 29th of January. So this is where it gets kind of weird to me, is that if they're asking for it in January 29th and the judge says they can have expedited discovery, well, that expedited discovery would have only been from the 22nd basically to the 29th at that point, right? Now, obviously it took a longer time for that to kind of come in, but the idea was they were having this event coming up in Hawaii, and Eric was saying that they were going to show up at that event and continue to recruit people, which they just found out Maboni was doing, right? So the idea would be to get the information leading up to that event so that you would be able to tell what was going on. But anyway, so what has kind of happened is they've turned over some documents, but most of them are irrelevant. I think 90% of them were just screenshots of WFG's website, then a bunch of them, which we'll talk about in a little bit, that were actually pertaining to the case they've classified all of those as attorney eyes only. And so that's kind of what they're talking about here. This 249 documents are classified as attorney's eyes only. And what that means is WFG can't know about it. So let's say, just theorizing here, it's a text message from Eric Olson to somebody who's currently in WFG and says, hey man, this event's coming up. Yeah, how did you do? Were you able to recruit some people over to GFI? And the dude with WFG and his wife is at GFI goes, yeah man, I got 10 people to come over this week at this event. That WFG would not be able to see. So WFG can't go in and stop the raid from happening because they are considering it retaliation. So really strange to me. Like, I thought that was the point of doing the discovery, was to stop this stuff from continuing to happen, but yet we just continue to draw it out longer and longer. It doesn't make any sense to me. So they're talking about the expedited discovery, excuse me, being on February 26th to collect evidence necessary to demonstrate its entitlement to preliminary injunctions against the defendants of the ongoing raid with WFG, right? So we would want the information, and then we would want to be able to see the information so that we could do something about this ongoing raid. And maybe it's not to the extent that we thought it was. We'll talk about the actual license numbers over at GFI that we have for maybe a month or so ago. But still interesting to me that he's kind of like ignoring, he kind of acknowledges that it's happening, but then doesn't really care about releasing the information to WFG. So, and obviously they're using the anchor leg strategy. And this seems to be, for the crooks out there, I guess I shouldn't be talking about this, but it's that's the way they're getting away with it, because they're basically saying, well, I'm an agent with WFG and my wife is an agent with GFI, so I'm not doing anything wrong because I'm legally within my rights to be within WFG. I just happen to be recruiting all these people over to my wife. But apparently Eric has found the key to be able to get around this whole system. You just use the anchor leg strategy, and then nobody's technically doing any. It's kind of like, I don't know, like every time you buy something, you know how it has like 15 pages of like, this is a bag, do not put it over your head. Like, you have to go through all of the things not to do with a plastic bag because you could die. It's because somebody's probably done that. And so we're kind of in this territory where Eric has found this gray area where he can get away with whatever he wants by using the anchor leg strategy. So maybe the next update to the law is we have to figure out how to classify the anchor leg strategy so that people can't continue to do this, which is sad. We shouldn't have to have 15 pages of things to not do when you're in the, I mean, it's already long enough trying to pass that test just to keep people honest from there. But anyway, on the 28th, WFG served the same 4 requests. So basically they were asking for information back and forth. And then for 2 months, nothing got produced because of the protective order, which is interesting. Remember this, because when we go in there and we see the transcripts, every time GFI talks about this, they say that they immediately turned over the documents. But that's not true. They waited for months for the protective order. We talked about all of that, and that they weren't willing to turn over those documents until the protective order was in place. But every time they would refer and talk to the judge, they say, well, as soon as they asked for it, we turned it over, which is, to me, seems like a lie, but I don't know how they're designating that. So anyway, WFG negotiated the terms of the protective order with the defendants in good faith. So they're talking about this, the classifying of documents. So inside of the protective order is going to be where these documents are going to be and how they're going to be classified. So they're anticipating that the defendants might attempt to conceal evidence through the attorney's eyes only designation, which they have done here. WFG proposed an attorney's eyes only provision that would allow WFG to maintain a heightened protection of confidential information which defendants are accused of stealing, while preventing the defendants from unfairly keeping WFG in the dark about the extent and details of the wrongdoing. So it's still happening, but they can say that they turned over the documents, but WFG cannot see the documents. Only their attorneys can. So it's very, very slick. Like, I swear Eric thought about every aspect of this, or it just happens to be falling into his favor. I don't know. But fairly intelligent either way. So defendants reject this position in the interest of time and efficiency and its reliance on counsel's obligation to comply with the designation parameters in good faith. WFG agreed the Olson's protective order. So what I see, and maybe this is just wrong, but WFG seems to keep conceding, giving up ground with the Olsons, with Eric and GFI. So it was on the time restraints for the discovery, then it was with what was in the protective order. So in the protective order, they didn't really want this attorney's eyes only provision, but they said that's fine, it just has to be very, very strict. So it's kind of like having laws on the book that nobody enforces. So they put laws around each one of these things, and in attorney's eyes only is supposed to be extremely sensitive confidential information or items disclosure with which another party or non-party would create a substantial risk of serious harm that could not be avoided by any less strict means. So it's very, very, like it's supposed to be used very, very rare. And now all of the documents that are getting turned over that have any substance are being put into this category. And it includes confidential information as to which the party producing it is also asserting in good faith that the information is so sensitive that the receipt of the information by the party or non-party would have significant adverse impact to the designated party's business, financial condition, or ability to compete, or would otherwise create substantial risk of harm that could not be avoided by less restrictive means. This includes trade secrets, financial needs analysis, projections, confidential contractual relationships with third parties. So yeah, let's say Eric Olson had information about a client that has their social on there and their financial needs analysis and that kind of stuff. Obviously, WFG doesn't need to see that, right? Like that's going to be stuff that potentially could be bad if it got out. So that could be attorney's eyes only. That would fall into that category of it's not really relevant information. They don't really need it. It's not going to help WFG with anything. And it's information for a client, so it really shouldn't get out, right? So that could be designated as attorney eyes only, but that's not really what they're doing. The identification of confidential consumers, materials relating to ongoing search and development efforts of forfeiture of products. Right, if he's got a prospectus or he's got an application, right, that gets turned over, social security numbers, all that important information, that can be attorney's eyes only. Technical materials used solely for the internal purpose of connecting with development, production, engineering, sales, and training. The protective order further requires the confidential designations be limited to specific materials that qualifies under appropriate standards and prohibits the mass indoctrination or routinized designation. So anyway, what they're kind of going through here is saying that they left this designation open in case there were client information that could kind of fall into that, and obviously these other designations. But they're using it for everything. So every time there's any documentation of the ongoing raid, it just gets put into attorney's eyes only, and then WFG can't see it and do anything about it. So kind of fascinating. And what we'll see in the judge's response is he just allows it to happen. So defendants make improper mass designations. Although attorneys committed to produce documents the day after the entry of the protective order, they did not produce documents until the 22nd, notably less than 12 hours before the deposition. Defendants produced 12,587 documents, 11,372 of those, 90% of which were not custodial documents, but instead were just screenshots of WFG's website collected by a hired vendor. So they paid somebody to basically go on and do 1,372 screenshots of WFG's website, and then they uploaded that with all of these documents for the case, which is kind of funny from a third-party perspective, right? Like, part of it is just you bombard the person with so much information that is irrelevant to the case. Imagine the like poor what do they call it? The person who's like helping out the attorney, whatever their assistant is, and they're sitting there having to go through, they're probably not doing pages, right? It's probably digital documents, right? But 11,000 documents of just like screenshots of WFG. Well played, right? Well played. That was pretty good. So, but 90% of those documents that they turned over have nothing to do with anything. In other words, the defendants produced a mere 1,215 documents that were actually relevant to anything, many of which were also public images or social media posts. So again, nothing that WFG couldn't have had or already gotten on their own. In addition to this attempt to bury the responsive documents, defendants improperly mass designated 978 of those 1,200 documents as attorney's eyes only. So again, you can see they're really not giving up many documents, and then when they do, everything goes into the attorney's eyes only if it has any relevancy to the case, meaning WFG can't see it. WFG's challenge with improper mass designations based on harm to WFG. On the 7th, WFG notified it and challenged these 978 designations in accordance. So remember, attorney's eyes only is supposed to be for that very limited, like maybe 5% of those documents that come over that have to do with clients or its social security numbers, things like that that might be in Eric's possession, being a financial professional, right? But he's basically, everything that he gets turned over that has any relevancy, he just puts it into the attorney's eyes only designation so that WFG can't do anything about it. And WFG challenged the defendant's designations for 3 reasons. First, it's improperly designated as attorney's eyes only, thereby prolonging the defendant's scheme to hindering WFG from understanding the extent of the wrongdoing and preventing further harm. They're referring to particular ones here, and we open these up, but they're attorney's eyes only, so that means we can't see them either. But apparently referencing all of these is showing that there's wrongdoing. That's still continuing to happen. Second, the defendants are improperly using the protective order to conceal their unlawful conduct from WFG by designating everything as attorney's eyes only communication, which again, there's more referring to more messages here that have been turned over. Defendants improperly blanket designate obvious public documents, including social media platform logs, internet memes, they're meme Bob, right? Public videos and public filings from this litigation. So they're turning over these things, which are internet memes, and they're designating them as attorney's eyes only. So they're just blanket everything that comes over is for attorney's eyes only, apparently. Given the immediacy of the risk of harm to WFG presented by whatever this is redacted, the ongoing raid of WFG, escalated its challenge to defendants' confidentiality designations with respect to only 2 documents. So they're not even fighting all of those previous documents. There's just 2 here that they want to declassify from attorney's eyes only. So they're not saying, let's go back and do all 900 documents, but there's 2 of them, apparently, that probably name names of other people who were previously involved or are currently still involved with that raid. And they want, this is the attorney saying, hey, we have evidence of wrongdoing and we want to be able to tell our client about it. Same thing as you hopping on the website and going, man, somebody's removing money from your account. I need to tell my client about this. And so they're fighting over the designation of these 2. However, the defendants refused to withdraw their designation or input their position in a joint discovery letter on an expedited basis, despised WFG's good faith for the request. Therefore, WFG sought judicial intervention straight away. Defendants opposed WFG's challenge on the 13th. The cousins held a hearing to discuss in part WFG's limited request for de-designation of these 2 documents, which we have the transcripts for, so we'll talk about that in a little bit. The court entered an order denying WFG's request the same day on the grounds that disclosure of the 2 communications of WFG may present a substantial risk, they're calling it, to retaliation of people who are currently with WFG, not to the defendants as required by the protective order. So the protective order is supposed to protect the defendants, the Olsons, but the Olsons are extending that out to protect anybody who's under the umbrella of GFI who may still be conducting themselves the way that they're not supposed to be doing. So, and the judge just basically said, yeah, that's perfectly fine, no big deal. We're not going to allow WFG to see that information because it could cause retribution is the word that they keep using against these people who are part of this ongoing raid. So the defendants filed their motion to retain confidentiality to address the remainder of WFG's confidential challenges on the 28th. Defendants agreed to redesignate 729 documents as confidential and sought to retain attorney-eyes only designation for 249 documents of the docket, the docket number 167. WFG maintains its challenge to all 249 documents designated as AOE because the defendant's designations are clearly abuse of the protective order, improperly designating material as attorney's eyes only in attempt to conceal and hinder WFG's ability to cease the ongoing raid. Accordingly, WFG respectfully requests the court deny the defendant's motions and order the defendant to downgrade designation of the documents in the defendant's Exhibit 2 of attorney's eyes only. The defendant wants to uphold the designation for these documents and list the defendant's Exhibit 2 on the sole and insufficient ground that something, and we can't see it. And I'm assuming this is that WFG would hold those people accountable for what they're doing. The court should deny the defendant's motions because the defendants failed to satisfy their burden to demonstrate entitlement to the attorney's eyes only protection under the terms of the protective order of the defendant's designation, purposefully hogtie WFG's ability to investigate and address the ongoing irreparable harm, and fairly prepare the forthcoming preliminary injunction hearing. And this is, I guess here the question is, like, it's been months now, right? And so whoever was going to move over has probably made that decision at this point, I would think, right? And so I don't understand the point in prolonging this, right? The idea should be, like, I kind of had to go through this with when my parents divorced, right? It's like, you go your way, and you go your way, and you two just stop fighting in the middle, right? Like, you started your own company, perfectly fine, go do that. But, like, why continue the raid? Like, at this point, it's just kind of personal at that point. So, I don't understand the point. Like, why can't you just go your own way? WFG go one way, GFI go the other way. What does that really matter, right? Like, why do we need to keep the ongoing raid and keep going through all of this charade of pretending like it's not happening? GFI and Olson saying that it's not happening, WFG saying that it's happening, we have evidence that it's happening. Why can't we just stop that process? Allow WFG to, like, cut off whoever wants to be with GFI. That's fine, go be with GFI, but why do you have to play in the middle? That's where it doesn't make sense to me. So I don't care if you want to go to GFI, I don't care if you want to stay with WFG. Just the point should be, like, make a decision. Don't sit in the middle and play the game of you're showing up to events pretending to be with one company when you're with the other. And I wouldn't want WFG agents going into GFI and recruiting them back to WFG either. Like, that just doesn't make sense to me. It should be about just make your decision and then go. So defendants improperly attempt to reassign the burden to WFG. So they're trying to make it their responsibility. They're trying to say, okay, we're going to turn over all of the documents as attorney's eyes only. Excuse me. And then WFG, you have to figure out which ones are not attorney's eyes only, basically making it WFG's job to do that. So instead, the defendants claim that all 249 documents are entitled to attorney's eyes only protection to prevent the disclosure of the people who are still working with WFG and continuing the raid. But it is obvious that the defendant's argument, which is meritless anyway, cannot apply to all 247 documents, and much of this is redacted. But basically they're saying there's no way that a meme can fall inside of attorney's eyes only. There's no reason why that should be in there. Defendant's improper attempt to shift the burden to WFG to determine which documents are and are not entitled to attorney's eyes only designation, thereby needlessly delaying WFG's expedited discovery, is abuse and should be rejected. And this is the whole point, right? Like, I don't understand why they can't just end it, right? Like, just split up, go your own ways, but instead we're drawing this out. And that seems to have been Eric's goal from the beginning, is just how long can I draw this out? How long can I leave people who are double agents and have some that are inside of WFG, they're recruiting over to GFI? How long can I allow this to progress for? And it seems to be working out perfectly well for him. And so we'll kind of skip through some of this, but they're just basically saying that the designated documents are not entitled to attorney's eyes only. They need to be extremely sensitive and create substantial risk of harm that could not be avoided. We've read a lot of that before. Here, defendants broadly seek to conceal WFG's 249 documents that are revealing this ongoing raid of WFG agents. Defendants do not identify any GFI trade secrets, analysis, technical information, sensitive information belonging to the defendants. This is unsurprising given that the documents do not contain any confidential information relating to GFI whatsoever. Instead, they contain, I'm assuming, information about what's continuing to happen in GFI continuing to raid WFG. For that reason, WFG agrees that the documents should be entitled to confidential designation, but they certainly cannot be cloaked as attorney's eyes only to WFG's prejudice. So the judge here kind of has to decide, do I allow these people to keep doing the raid, which I thought was the whole reason for the expedited discovery, was to stop the raid on WFG, but yet he sides with them to basically just say that it continued to happen. Defendants also fail to identify substantial risk or harm to significant adverse impact on the defendant's business. So part of the attorney's eyes only could be, well, it would impact my business if WFG knew this. So let's say there was, I don't know, some contract that they had with some carrier that gave them a higher rate. Well, it might not be a good idea for WFG to see that because WFG doesn't really need to know. So, but knowing that there are people inside of WFG and still rating it is information that they need to know. How is that a substantial risk of harm to Eric? And this has kind of been my comment from the beginning because I was hoping Eric was going to come out and actually have some information of WFG's wrongdoing. And we still haven't seen any of that. I'm still waiting for that. Haven't seen any of this. But then he somehow says that if he's not able to continue to take clients and agents from WFG, that is substantial risk of harm and an adverse impact to his business. That the only way he can conduct his business if he continues the raid with WFG. So I don't know how that works because even the 16600 designation for California, that law is all entirely built on the premise that Eric cannot do his insurance business and with clients and agents unless he's raiding WFG. That's the only way that qualifies. So, which sounds wrong to me because can't he go out and recruit new agents? Can't he go out and build his agency on his own? Why do we have to keep having the fighting between the two of these? And that's really why the only part that I really care about this is that are we going to allow that to continue to happen where these companies continue to fight between the two of them and they're pretending to do stuff? It's like, can we just cut the baby in half and everybody goes their own way and we can all be happy? So instead, the defendants argue that preventing WFG from doing the documents is necessary to prevent WFG from retaliating against these agents that are still working inside of WFG. That's just my assumption on what's there. But any impact that the de-designation would have on the information is irrelevant and does not constitute substantial harm or any competitive disadvantage to the defendants, as the protective order requires, and any potential action by WFG against those particular agents is not retaliation, it's WFG's contractual right. So they're finding out people who are continuing to break their contract, and the judge is saying, well, you can't do anything about it because that's considered retaliation. So kind of interesting. They cite their motion. There's going to be some case law here. It is WFG that would suffer substantial harm in the actual prejudice of the defendant's strategic and improper attempt to withhold this evidence from WFG. The defendant's attorney's eyes only designations have placed WFG outside its counsel in an untenable position of not being able to share WFG the ongoing and irreparable harm evidenced by the defendant's production. This is exactly right. So it puts the because the attorneys could get in trouble. So imagine you're having to talk to your client. You know that somebody's stealing money out of their account, but you're not legally allowed to say it. And if you say it, there are serious repercussions that could happen. So let's say it slipped out and the attorney is talking with WFG and they happen to mention somebody's name on accident, and WFG picks up that this person's still with WFG. So it puts them in a very interesting perspective where the attorney, this is a very serious relationship between an attorney and a client. The attorney has to continue to lie to their client about what they know. Now, if it's a social security number, right, that doesn't matter for a client. That's not a big deal. They're not lying about withholding that information. But knowing that there's continuing theft that's going on, if you want to call it that, they cannot have that conversation with their own clients, which puts them in a very interesting perspective. So the broad designation of the bulk litigation it puts the burden on the shoulders of outside counsel, which could hamper the designation party of the defense at least to some extent, since certain topics may not be discussed by outside counsel with the client directly. That's absolutely true. So the attorney then has to walk on eggshells about what they can say to their own client. It's kind of like having to lie to your wife about something, right? Not a good idea to do. So resulting in WFG's hamstring in its ability to learn and protect against its ongoing raid on its business and prepare for forthcoming preliminary injunctions. Then they reference particular files there. Further, outside counsel's inability to share the defendant's documents with WFG is a significant impairment on WFG's ability to prepare for upcoming preliminary injunctions. So if you can see how this divide starts to happen, what happens when WFG's in the room and their attorney's in the room and they're having a meeting with the court, and the attorney then needs to talk about somebody who's been brought up in these documents. Well, does WFG then leave the courtroom? Because you can't have, you both have to kind of be there, right? Does the counsel go outside of that meeting and talk directly with the judge? It just creates all these really weird scenarios that shouldn't really be happening, where communication then has to be careful. What happens if the attorney starts to talk about this and it's part of something that's classified attorney's eyes only, but WFG is there? It just makes it very, very messy to proceed from here. And so they're just bringing this up in that it makes it hard for everybody to do their job if we're going to continue down this road. Without that, WFG is significantly prejudiced in its ability to prepare for the preliminary injunction because they can't know about these things that are happening. So everybody has to be on their tippy toes when they're talking about anything, otherwise they can get in big trouble for sharing this information with WFG. So the court could prevent the defendants from any further obstruction and order that these documents be downgraded to confidential. So if they're downgraded to where they can have this conversation with their own clients, well then all of these other issues start to go away. But they're creating all these issues coming up if they continue to do what they're doing, okay? So let's see what Olson's side of this is and how he feels about the designation of these documents. Switch back over to the red. All right. In pressing forward with trying to remove the defendant's confidentiality designation, WFG neglects to mention that the court already rejected the same argument WFG reiterates here. After the court denied WFG's motions to de-designation two documents on identical grounds, WFG has withdrawn its objection to his motion, which WFG forced defendants to bring to avoid consuming judicial and party resources. Unfortunately, this is not the case. The central issue in this case in the Olson's forthcoming preliminary injunction motion, WFG's campaign to enforce, so this is where it all hinges around, and this is the only reason why I care about it. So WFG's campaign to enforce its illegal restrictive covenant against its current and former employees. This is the crux of the entire litigation. The entire case is based on this one sentence right here. Is having a agreement with your agents considered illegal restrictive covenant? So the non-solicitation the non-disparagement, and the confidential information. This is where it matters for me. Outside of it, I could care less. But this is where it starts to impact the rest of the industry. If we decide that no company is allowed to have any kind of agent agreement, I don't know where we go from there. That there's no restriction on what the company can do, and there's no restriction of what the agent can do. This is where it starts to become important for everybody. Whether you're a GFI side, whether you're WFG side, this is where it becomes important. Because if this is ruled against, and we say that everybody can do whatever they want, they can non-solicit all they want, they can non-disparage all they want, they can take whatever confidential information they want, that hurts the rest of the industry. So it doesn't matter where you go after that, every company is going to be impacted by the decision of this court, and that's why I care. So the narrow subset of these documents that reveals the identities of current and former WFG agents that are not affiliated with WFG to prevent WFG from retaliating against them by threatening to enforce that illegal covenant. So again, is it illegal to say, hey, don't steal from us, we won't steal from you, right? We need to have some kind of agreement in place. Then they're saying that that's illegal. So if every single agent agreement is going to be deemed illegal, it's going to get us into some interesting territory into the future, and it's not going to be a place that we like to live. And so they're admitting here, and this is where the anchor leg strategy is so brilliant, is that technically, if you look at it by the law, they're retaliating against somebody who's in WFG. Not mentioning that the spouse is with GFI, right? So it looks different than if they were coded with both, because that's obviously, you're not allowed to do that. But there's nothing in any of this documentation that says you can't have your spouse do it. So that's where they're kind of playing this game on both sides of the fence of saying, well, that person's not with WFG, it's just their spouse that is. So that's how they're kind of protecting these GFI agents that are playing the fence on both sides. And I don't think it should go either way. I wouldn't like WFG agents in another company trying to recruit people over. Like, I think there's plenty of people out there for us to recruit and sell to, that we don't need to be bickering in between the companies. So, and for these admitted, and that's what WFG wants to do. And so that's why they're designating these documents as attorney's eyes only, so they can't retaliate against people who are continuing this ongoing raid. In violation of the protective order procedures, and while the Olsons were preparing this motion, WFG filed unilaterally for down designation of 2 documents, asserting that the down designation would necessarily so that it could investigate its current and former agents in response to the Olsons argued that highly confidential designations was appropriate because retaliation via the enforcement, here it is again, of illegal covenants readily constitutes serious harm. So everything in this case is built around that 16600, because if that's illegal, then of course what WFG is doing would be considered serious harm, right? Like, if you did something that was legal and then somebody goes after you for that, well, you were allowed to do it, so you can't be retaliated against for not doing something illegal, or for doing something that's legal, not doing something that's not illegal. Then obviously that would constitute serious harm. So we've got to figure this part of that out, and whatever happens here is going to be the impact on the industry. So the court ruled that such risk of retaliation is sufficient basis for highly confidential designation and upheld the Olson's designation as to certain of these documents, which is interesting, right? Because here's the other perspective of it that comes to me, is the reason why we couldn't get information from Welsh and from Carter was because they were independent contractors, right? Like, the whole idea was they're not employees of GFI. But then if we were to turn that around and say, well, they're not employees of WFG, they are independent agents, well, then that gets into another realm of, well, now you're breaking your contract. I guess it goes back to if you're breaking your contract or not. So that's where all of this kind of falls back into. So WFG's opposition fails to address the court's order or establish case law providing that the potential for retaliation is an adequate ground for designating documents under the attorney's eyes only protective order. So that's exactly, you can see it here clear as day. GFI is not saying that they're not continuing to do it. They're basically saying that we want to continue to do it. We just don't want WFG to go and retaliate against these people, whether previously or currently working with WFG. Nor does it offer any contingent reason why simply trying to provide expedited discovery should result in adverse and unjustified consequences for non-parties. You can't make this stuff up. I mean, it's right there. I don't know if you guys find it as hilarious as I do, but okay, so the whole reason of doing expedited discovery was to stop the ongoing raid. Yet they're saying that the information that they're turning over should not be allowed to be used to stop the ongoing raid. So that's where we're at. I know. That's why I couldn't do this job. Instead, WFG rehashes the same arguments that this court already rejected, namely that WFG needs access to these documents to prepare for its motion for a preliminary injunction. But just like, so think about it, WFG left open in this lawsuit names for co-conspirators, people who were part of the raid. But WFG can't even add those people to the lawsuit if they're not allowed to know who they are. So it's this weird, like, protective area that they're just not, they literally are hogtied, in the words that they use, to be able to do anything from here. So WFG's assertion that its planned motion depends on WFG's access to these documents make little sense. The attorney's eyes only designation does not deprive WFG's lawyers of any information to use in support of the motion. In any event, any purported injunction would have to be based on the defendant's activities, not those of third parties. So here they're hiding, and they've been doing this from the beginning. So the whole way that Eric's getting out of this is he's saying, well, I'm not the one who told Matthew Welsh to help my wife start this company. I'm not the one who told Eric Carter and Cofield and all these other guys to do the things that they're doing. They're doing it on their own. So it's not based on my activities, Eric Olson, and it's not based on what he's doing. It's now a third party. See how it becomes a third party when it's their people who are doing it? But when it's part of WFG's people, then it's like, well, now it's WFG's fault. So it's just interesting how they're always playing both sides of that. And they're just great at what they're doing. So, but that should be part of stopping the ongoing raid, right? Is knowing those people who they don't know yet. And so what's interesting is they're saying, well, the lawyers can still do whatever they need to do in support of the motion, but not really, right? Because if they put the name into the lawsuit, well, WFG then can't go in and read the documents for that lawsuit, right? So now it separates the client and the attorney into where they can't even be part of the discussion at that point unless the attorney's then giving that information over to WFG. So it's interesting how it's going to create that divide between the two of them. And before, WFG focuses its efforts on again arguing that it's need to access these documents to retaliate against current and former agents. Well, how do they get added to the lawsuit if they don't know who they are? A purpose that this court has already found to be impermissible. So, according to the Olsons, respectfully request that the court grant their motion and order that they be permitted to maintain a highly confidential designation on these documents identified. So, to reiterate that, we want to continue having people inside of WFG to get whatever information it is that we want. The Olsons have met their burden to show that disclosure of 249 document designations of highly confidential would create substantial risk of serious harm because WFG could use them to retaliate against agents who spoke with the Olsons by enforcing its illegal covenant. According to the Olsons' request, that the court uphold the Olsons' designations. So as you can see, they keep going back to this thing. So yeah, I think I've said it enough. You guys kind of get it at this point. But while the Olsons were preparing this motion, WFG unilaterally sought immediate designation of these two documents, of course, in the violation of the protective order procedures. So anyway, I think that gives you guys a pretty decent understanding of what's happening there. Let me see if I can just kind of run through this really quick. the down designation would create serious substantial harm because WFG admits that it seeks access to these documents to continue enforcing illegal restrictive covenants that are core to this case. So yeah, they want to do something about the people that are continuing the raid, which I thought was the whole purpose of this thing. So from the start of this dispute, WFG has stated that it seeks down designation to these investigations. Individuals can consider whether to enforce WFG's illegal covenant against them. Which is so funny, because why would GFI have an illegal covenant if they're illegal covenants? GFI had everybody sign a agent agreement, so why is GFI enforcing an illegal covenant if it's illegal for WFG to do it? I don't know. Can't make this stuff up. And now, even following the court's ruling that such retaliation was sufficient based on the highly confidential designation, WFG agrees to argue that access is required so that WFG can identify active agents that are in the breach of their contract. 100%. They just said the quiet part out loud. Yep. That's 100% what they want to do. WFG fails to address the court's ruling that potential retaliation with WFG is sufficient based on the highly confidential designation and fails to provide a single reason why that ruling does not apply to the remaining 247 of the 249 designations. On this, the court has not yet ruled. Well, they're just not arguing. They found two that were important, and they want to designate those first. Maybe they don't need the other 247. Maybe it's just the two that really show that it's important. They're saying that these designations do not prejudice WFG. So the Olsons are saying that them not knowing who's inside of WFG continuing the raid does not hurt WFG. Seriously, that's what they're saying. So just as it did before, WFG argues that the designations interfere with WFG's ability to seek a preliminary injunction. It's claimed that its purpose is to seek expedited discovery. This argument fails for at least three reasons. WFG already unsuccessfully argued that access to these documents. WFG offers no evidence for counsel is not able to prepare for the preliminary injunction against the Olsons for violating WFG's illegal covenant without allowing WFG's access to the documents that it would use to harm the third parties. That's absolutely true. The attorney cannot continue to do their job without having this conversation with WFG, because one of them is going to have to be excluded from every single conversation going forward. Every document that's filed, one of them is not going to be able to see it, because if there's listed in the documents information, WFG is not allowed to read any of that information continuing forward. So WFG only makes the statement that downgrading the designation is necessarily for counsel to be able to identify current and former agents, distinguish WFG's confidential information, and explain each instance of misappropriation. And third, none of the purportedly confidential information identified WFG is actually confidential. Originally, WFG challenged two documents containing text messages from somebody identifying the names of WFG agents on a group thread and a screenshot of WFG announcements regarding WFG's policy change. But the identity of WFG agents in the group chat are not confidential, as WFG publishes this information on the internet. Moreover, Mr. Olson was already aware of the policy changes because it was made in response to his attempt to avail himself of the policy. In fact, this is one of the allegations in his complaint against WFG. Fair point here, 100% accurate. I think what WFG did in this process did not make sense. It didn't make sense legally, and I don't think it was fair of them to necessarily do. I don't see how it even helped, but that's a different conversation that's outside of expedited discovery. WFG agents already have likewise posted similar announcements about the policy change on social media. WFG offers no evidence supporting which materials are confidential in its moving papers. So in their opposition, the only additional purported confidential information that WFG identifies are advancement guidelines, leaders bulletins, letters from WFG and former employees, confirming resignations. None of this information is confidential. Numerous variations of WFG's guidelines are readily available on the internet. WFG's agents have posted leaderboard information on social media. Advanced guidelines to which they obtained on the internet are public record. And obviously the fact that an agent resignation is not confidential information. And the Olsons say that they have met their burden of proof. All right, so let's go into, I know this is a lot and I apologize, we're going to kind of wrap this up as quickly as we can. So let's go into the actual conversation of what happened at the meeting. I found this to be fairly interesting. So we're going to skip this first part but this is the actual transcript of what came through. This first part is dealing with Nathan Showrack, and basically they're just saying, if you want us to produce the documents additionally, then we need to do it in our actual home state. And so not really relevant information there. I'll post it on Locals. If you want it, you can go in and read it there. I'll post all that on there, but we're going to skip this first part because it's not really pertinent to what we're talking about. All right, and then what we're looking for starts in here. All right, so returning to the agenda now on the 171, I want to resolve one issue first, given the opportunities to guide me and others, a bullet point in this discussion about the appointment of a special master. Remember, the special master is supposed to come in and help make decisions quickly so that they don't have to wait for the court to happen. They could not actually come to an agreement on that. Given the lack of an agreement on it, the fact that you've presented me with your agenda and proposed orders to resolve the issues before the court now, and I intend to resolve them at this hearing and after, so that is a question to be addressed in future if needed by the judge. This agenda was filed just 3 days ago, but there are other agenda settings items that the parties have discussed that you want to put on the agenda. Okay, the court, Mr. Brodin, go ahead. Yes, sir, from our end. All right, I think that we would propose to take them into presented agenda. All right, thank you very much. Go about 10 minutes, let them take the, sorry about that. I thought I had this queued up right. Prepared to talk about them now. Significant matters that give you time, give you a chance to tell them, respond. Drew, you've got the floor. Okay, thank you, Your Honor. I think the issues most pressing for today I would like to address first is the date range. Okay, so this is WFG, I believe. WFG's counsel who's talking about this is Drew. Court, yes. Okay, so we have submitted just 4 document requests as part of the limited expedited discovery, and the defendants have imposed an arbitrary cutoff by which they will not produce documents predating to one of the 2 defendants' termination of WFG. The complaint in this case is clear that the misconduct and the allegations about the defendant's actions clearly predate by several months any of the date that he was terminated. So obviously the raid was happening before he was terminated. As part of obtaining a preliminary injunction, we are required to demonstrate a likelihood of success on the merits. So certainly evidence regarding those allegations of Mr. Olson and his wife, Miss Olson, were doing during the period of time between September of 2023 and the date of his termination are relevant evidence that are critical to our ability to demonstrate the likelihood of success on its merits. The court responds. Can I ask about this? So in the agenda 171, you ask for production of September 1st, 2023 to present. Does present mean today? What's the proper? Basically, what are they asking for? I think you could do the date of the collection. It's my understanding from so they collected information, I think it was April or May, when they actually, they might have done it in February. I'll have to go back and look on that. But basically he's saying to whenever they collected all the data, because if you remember, they collected hundreds of thousands of documents at the time that they were sitting down. But somehow we got into this area where they decided to only turn over the documents after the termination. And so whenever they collected those documents, he's saying that's fine. We don't need stuff after that. We just need the stuff before it that you've already collected. And it's my understanding from our conference with counsel that they have done a fulsome collection in the interest of making sure obviously everyone is adhering to their obligations under the preservation, so that would be our whatever the date of collection, which I understood happened at some point after this lawsuit was filed and commenced. Do you have an estimate as to what that date was? I could, just a moment. Yes, Your Honor. It was dated in March of 2024, as we understand. I'm not sure the exact date in that month. The court says, what's that? What's the rationale of the September 1st? Why that date and why not an earlier date or a later date? And then WFG's counsel responds, sure. I think we could go an earlier date, but September 1st is actually the compromise that we offered to the other side as part of our efforts in resolving this without the need for the court intervention. In the complaint, Mr. Olson and Mr. And in Mr. Olson has a related case against WFG, and he has made allegations in September of 2023, he was engaged in conversations with the company about wishing to sell a portion of his hierarchy. And based on those conversations, that was part of his impetus for his decision to leave ultimately, or set up a competitor with the company. So that was the basis for that date. Miss Olson, for her part, left WFG in October of 2023 and set up GFI, which is the competitive agency. Just 2 days later, on September 6th, Miss Olson has submitted declarations to this court that he was not involved with GFI prior to his termination. So from the information that we have, we know that not to be accurate. But here's where they get to kind of play that game, in that they go, well, Eric was never on camera, so he wasn't really part of GFI. It was just this thing that his wife was doing. Again, the anchor leg strategy working exactly how it's supposed to work. I think we're entitled to test the veracity of that statement to this court as part of the discovery. Yeah, was he lying? If he was lying, then that brings in information that I think is important to the court and what actually happened. This court, as part of the discovery, indeed have evidence that is entirely to the contrary. So they're saying that they think that he lied. That has come from non-parties and also from Mr. Olson's own communication with WFG's witnesses in real time. So it's certainly on the relevance issue. I think we are well in our right and our position there. The sole case that the defendants rely on for their position is this particular one, and that's 379. The case actually entirely supports a plaintiff position, Your Honor. The Olsons rely on it for their premise that the court cannot fashion injunctive relief for events that have already occurred. So they're saying that because it's already happened, it's already happened. There's nothing that they can do for the injunctive relief, and that may be an injunctive holding of that case. But as to the expedited discovery, the court drew no such distinction. And in fact, GFI's counsel on this has been absolutely fantastic on rewording these things to make it sound like it is. They've been great on that. Where they go, well, you guys made a statement over here, and then they loosely relate it to something else, and all of it gets included in there, and then the court just says, oh, you're right, we did already agree on that. And in fact, the special master in that case did order discovery that concluded discovery of pre-termination activities. Specifically, the court said, with respect to some of the information about communications from a laptop, that the parties were required to produce evidence which contain or have ever contained the company's confidential information there. So the sole case on which they rely supports the plaintiff's position, and moreover, Your Honor, in the defendant's questioning of some of the agents who have been deposed here, Mr. Showrack, questions were asked that the witness about events and activities that occurred prior to Mr. Olson's termination from WFG. Because remember, Olson is saying that he was terminated for no reason. They just came in and fired him for no reason. And then we go back and we look, and you can find this on Locals, the timeline of when he was recruiting other agents in previous to his termination. That's why he got terminated, was for breaking his contract. So defendants cannot have it both ways, Your Honors. They cannot refuse to produce relevant evidence based on this sort of arbitrary date distinction that they have drawn out, but then simultaneously seek discovery on their own events occurring prior to Mr. Olson's termination. We are simply asking that they have required to supplement their production, just as those 4 requests to provide evidence, which is certainly relevant here, and the defendant's conduct in between September 1st and January 22nd, and that is our request, Your Honor. Okay, thank you. Got it. All right. Anything else? Drew, I don't know if you want to go back and forth on this specific issue, but they want to bring up the idea of the attorney eyes only, and he says we can come back to that after this. He says, okay, perfect. You're the court, Mr. Broden. This is going to be counsel for Eric. I want to give you a chance. Thank you, Your Honor. The expedited discovery here is supposed to be for a preliminary injunction. And you know, WFG has taken the position that they have filed a motion to compel arbitration. They're not going to produce any merit-related discovery, and they're not going to do Rule 26 disclosures. So we're talking about stuff that is, you know, only focused on the injunction. This this discovery had a 5-day turnaround period, which we complied with. You guys remember that? I brought this up earlier. Did they comply with the 5-day turnaround period? Because I thought they argued for the protective order for like 2 months. So I don't know how that still falls within it. But they're great at stating this stuff, and then WFG never really fact checks the timeline. They need to do a better job on keeping these guys straight with the actual timeline. My team worked really hard around the clock and late nights and weekends to get this production done and get it over to them. They did not do the same thing for us, and they took months and months to do it. So interesting how like they can delay for months and then it gets put on the other side. They're great at like manipulating the situation into making it everybody else's fault. And then they filed a motion to compel on the date range, which you know in the docket 81 was page 11. The court denied that motion. So again, like they reword things. So in there was not to compel the date range. That motion to compel was to actually get the documents. So because they weren't getting them. So do you see how they do a great job on flipping this around on the other side? So GFI is waiting for months. They finally get the protective order. Then they start turning over some documents, but nothing really relevant. And then WFG comes in and says, "Hey, we need your help, court, to actually can you compel them turning over these documents?" And then they go, "Well, that gets denied because they're kind of still working through the process." The judge says, "Hey, you two kids, you figure it out. You argue amongst yourselves, and then you get back to me." And then they turn this into being denied on the date range, which was only part of the entire document. A very small part of the document. What more importantly was they wanted the actual documents to be turned over. WFG again moved to the judge to have that date range expanded out, and the court judge denied that. Again, I don't remember reading any of that. Maybe I'm wrong. But the date range was not what was denied. What was denied was the motion to compel, for the judge to come in and force them to give up the information. And now we're back here again on the same issue. And that's the We Ride case does govern this case. That one of the 4 reasons I think that the court should continue to deny this request to expand the date range is the We Ride case. Davila said that he wasn't even going to consider success on the merits for the claim that happened before in this previous case had left the We Ride. And that's on page 852 of the opinion. And what judge said, the court declines to assess whether We Ride is likely to succeed on the merits as to its theory that Heng breached paragraph 6 only applying during the term of Heng's employment, but Heng no longer works for We Ride. We Ride was proposed, and the court cannot construct injunctive relief that would preserve the status quo to that paragraph 6. So that's another reason why this discovery is not appropriate. The third reason why this discovery is not appropriate is just given the sort of time frame that we're dealing with for production, this stuff, and the fact that it needs to be over. You know, there's stuff that happened that Mr. Olson is interested in that happened before then, but WFG has produced documents with the same January 22nd date range that we're using, so it's not on us to try to have it both ways. So what he was asking for was the temporary restraining, those people who approved filing for a temporary restraining order. The temporary restraining order didn't come in until after the 22nd termination. So Eric was terminated, he sued WFG, WFG sued him, those days were very, very close to each other, and then after that, WFG filed for a temporary restraining order, and apparently they got some people's approval for that. So the documents that they would have would not be, they wouldn't be talking about a temporary restraining order before Eric was terminated. It would make no sense because he wasn't terminated yet, there was no lawsuit yet. So then they're then saying that because the documents that they wanted was after the termination for the date range, that they don't need to then turn over documents prior to that because they weren't talking about a temporary restraining order before Eric got terminated and before there was a lawsuit. That doesn't make any sense. So it's them that are trying to do it. And at this point, we finished the document production. This would cause significant difficulties in expanding it. The original date range from the very beginning was September 1. It was all the time, and then WFG came back and limited it from September to the termination. or whatever date they produce documents. So but they're making it sound like it was this and now WFG is doing this. No, it was this and WFG did this. And we think the discovery should be over. So we don't want to turn over any more documents, Your Honor. We're just done with this. We think we should move on. So like we have with documents. So we're taking the depositions and we're going to our PI, and it's prejudicial to us to have to continue this expedited discovery process because we're going to have to move to a preliminary injunction too. Our client needs relief as well, right? Because Eric Olson was wrongfully terminated. He has done nothing wrong other than breach an illegal contract, the same contract he offers at his company. So interesting. And so this process should not be prolonged. We should be done with discovery because we prolonged it and now it's just taken way too long. So now we're just outside of the time frame to do it. So, and I feel like we're moving away from the point of all this expedited discovery, which was in judge's original order, which was that there was a conference that was going to happen in early March. That conference has come and gone several months ago, and then the PI briefing, and so now all of this is just getting way outside of and expanded. And we were here just last week. They want us to run additional custodian. We ran the custodian, we produced the documents, but every time we ask for, or they ask for something, we try to give it to them. We try to avoid the motion practice, but then they just ask for something else. And so I think there just needs to be like a final line drawn here so that we can be done with this and get on with the case. So from the beginning, WFG has set that same time frame. But then the Olsons are the ones that keep asking for things like Showrack, I think was the guy. So he came in and they asked, like, look, hey, if you want the metadata, you need to pay for it. Like, can you help with some of these costs since you're asking this person who's not part of the lawsuit to turn over information? The Olson said no. So Showrack came in, went down to the lawyer's office for hours, turns over all of this additional documents, and now the Olsons are saying that they didn't turn over what they wanted because they didn't ask for certain things that they wanted. So Showrack complied with everything that they wanted, turned that over, and now they're saying that they want more information from him. So they're the ones that keep asking for more information, but yet they turn it back on WFG saying that they're asking for more information. The court. All right, thank you. Here's the ruling request about the date range, docket 120, which is WFG's request is denied for these reasons. One, the issue is litigated before in the dockets 92 and 17. I've taken the consistent position, which is not to expand the date range as requested. It was never expanded. It was only shrunk. And that's because of the context that we're in, which is this is supposed to be focused on the limited discovery that has a short time period. Mr. Broaden has represented his clients, responded during the time period that was ordered, and this is a request for additional discovery beyond that. It's not additional discovery. It was this. They shrunk it down to this. And I don't find that there's a basis to do so under the rules for common sense that additional discovery with a broader date range would be disproportional to the needs of the case. It's too much work for them to do to find out everything that happened before. And part of my consideration in this reciprocity of the something indiscernible about what discovery WFG has provided in response to the request in the other direction. WFG's counsel says, Your Honor, I apologize if, court says yes, if I may be heard on that. We specifically offered the other side to conference and expand the date range and were told that we did not wish to receive that. We are prepared to produce the earlier date range as early as Monday if necessary, but I just wanted to make sure that that was known. I'm going to interrupt. You could have worked it out before, but today and come to the stipulation, but you didn't. So I have my ruling, and that's my ruling, and part of this informed by the discovery in which I've seen now in quite a bit of the record with filings and hearings before me that I don't see the fairness basis in granting you more discovery. If anything, it's going the other direction. So he's saying that WFG needs to produce more discovery. And so that's the ruling. I'm not expanding the discovery, and that's consistent with what I've said before, and it's corroborated by what's occurred since those earlier rulings. And now I'll hear the confidentiality designations. Thank you, Your Honor. Jamie, World Financial Group. We are requesting a de-designation of 2 documents identified in the docket number 142. Sorry, yeah, the focus of today, the 2 documents that shown the ongoing harm by current WFG agents who is sharing confidential information with the Olsons, which is our key dispute. So apparently, there's current WFG agents who are continuing to give information to the Olsons, which is the key dispute, right? The whole idea behind gathering this information is to stop the ongoing raid. And the court has found in this particular case that by using attorney eyes only designations, attempt to keep the catalyst officers from viewing documents and preparing its defense. They installed a stone wall between the defense counsel and his client. Absolutely true. You're not allowed to talk to your defense counsel. Defense counsel and the client now have a wall between them because there's information that they cannot talk about in the case. And that is exactly what's happening here. We are not able to share the document with our client, and we are not able to properly prepare for the hearings, and we're not able to stop this ongoing harm. This is not retaliation, as the defendants will attempt to say, because the agent is breaking his contract with WFG and causing harm and furthering the scheme that defendants are orchestrating. I'm surprised they let that come through. Normally they block that out. So it's a guy, whoever it is. And in the motion to retain confidentiality, I know that it's not the issue, and we will be opposing that in responding. However, we got the motion that was the first time that we saw the list of documents they were seeking to de-designate, and so we're still going through that at the moment, but the focus right now is on these 2 documents. The balance of harm clearly weighs in the favor of harmful to WFG. It is actual, ongoing, and significant versus the potential risk of harm for the Olsons. Moreover, the protective order provides for protection against highly confidential designation to protect harm to the Olsons specifically and not necessarily to the unrelated party. The court. And as to the newly filed motion about the confidentiality designations, which was set on the hearing in July 10th, I am not resolving that motion today, but you need to respond to it. Are there legal arguments that you make in more context as to that motion before I actually resolve this? Or do I have enough information now to resolve the issues from your perspective? Thank you, Your Honor. We will be responding to that in a separate issue. However, it just again shows that there have been appointed attorney eyes only designations, which was not allowed in these other cases. The constant case law before the court, but we will be responding more fully to that, and today's focus is on those 2 documents. Thank you. All right, thank you. Counsel for Mr. Olson. Thank you, Your Honor. If I might start with the same question, do you have the information I need, or will I need to consider the things in your newly filed motion for context? The counsel for GFI responds, I think there's enough information here for the court to make a ruling as these 2 documents. I think the court's ruling as to these 2 documents will probably have an effect on the pending motion, because I think it just comes down to the issue of, I think there's really 2 points here, Your Honor. The first is this is another instance of WFG using its limited discovery that we're producing for the purpose of other than seeking preliminary injunction, because they want to take action against somebody who's not a part of this case, who they believe is violating their duties. It's not what we should be doing at the expedited discovery process. The courts have protected this kind of perpetual retaliation because we say that they don't have the right to fire this person, and he's not taking confidential information, that they shouldn't be able to retaliate against him because based on anything that we're doing in this case and this expedited discovery process. I thought the whole point was to stop the continuous raid, but they're saying they shouldn't be able to retaliate against these people. And that's the Garcia case where it said fear of retaliation was appropriately resolved by the designation of those documents for attorney's eyes only, and cites that in their paper. And we're going to wrap up here shortly. And it's an employment case out of Seattle. So again, employment is different than when you're a contractor. So very similar to the district court, where they're again upheld by the confidentiality to protect the people to remain working at the company, and it's appropriate here, and it's not going to prejudice them and their ability to seek preliminary injunction. And all it's going to do is just to keep the status quo, keep the safety of this individual preserved, preserve the issue. We can fight about that. It will get decided by the judge whether their restrictive covenant is fair and legal, whether they're allowed to make actions against people like this. And so I think that there's sufficient information right now, just based on all of the arguments and allegations that are in this case, going back and forth, it should just be protected. And we didn't make a blanket designations. We did our best under the time constraints. We designated a number of documents in response to our meet and confer process, but we brought in the motion to protect, and all of this, it's raised in the appropriate mechanism of the court, actually identified as a protective order, but I think on the merits they should win. So the court responds, all right, thank you, Your Honor. This is going to be for counsel for WFG. It says, Your Honor, there has been no discussion yet as to the termination of this individual, but we're seeking the process right to confer with our clients and share this information. Moreover, it is impeding our ability to prepare for the PI hearing because we are not able to work with the client to develop this key part of our preliminary injunction motion, which would be the effect of confidential information, which is exactly what the court pointed out. And the court said, all right, thank you. I'm going to take this under consideration, under submission, and we'll have a written order in a few days. And I've ruled on that. Okay, so this is going to be counsel for Olson, sure. There's one very small issue, and the issue is that the used document that they had not produced in the deposition of Manuel Valle. We think that, proposed order, there should be a very narrow about the subject matter exclusion of the evidence that they obtained that way, because obviously they have the document. They've had it in their deposition outline, they plan on using it, and they didn't produce it to us, and that's just not fair. So this is going to go on to talk about Valle, so it gets outside of what we're talking about today. But basically, they showed Valle a document, maybe it was some kind of text message that he had, and so Valle was saying, hey, I never did anything, I never asked people to download their client information. And they go, well, what about this text message from such and such? And it was basically proof that he was lying during his deposition. And then now the counsel is saying, well, you never produced that document to us, so it's just not fair that you should be able to use that against him. And then they'll go on and say, well, we did turn it over, but we had it there. And so it was it wasn't really for the case, it was just to disprove that what he was saying, that he was lying to the court. So anyway, so that's going to kind of wrap that part up. So interesting to me that the judge just kind of allows it to continue to happen. So that's where we're at. And so kind of interesting as far as that goes. Let's see if we got some comments that we can talk about. Patrick Bet-David left his own version of it. Patrick selling the company. Yep. PHP. I don't know about that. I think Patrick was doing a great job. I think Patrick was making way more money doing his podcasts and stuff than he probably was running PHP. I don't know. I think that was just the direction he wanted to go. I don't know if it had anything to do with the company necessarily, but who knows? Good question. So anyway, the last thing I kind of want to cover is I may have been completely off. So part of what I keep seeing from GFI is how they have 14,000 agents, right? Well, somebody had sent this to me. They had screenshotted it, and so I'm going to bring that up. And so this was sometime in May. Okay, so they had released this into their I don't know if this Facebook. This looks like Facebook to me. So, but basically from GFI's own account, and they put this out sometime in May. Somebody had sent this to me that they were all aboard next up 1,000 licenses. So this is May, June. So we're less than a month after that, and they were saying they were at 1,000 licenses. So maybe there's not as much of a raid happening as is my head blocked? No, my head's not blocking that. So maybe there's not as much of a raid going on as I thought. If they're less than 1,000 licensed agents, maybe they just crossed over 1,000. Somebody was saying the range between 800 to maybe 1,200 licenses, which is a big difference between 14,000, right? So maybe it's not as big of an impact as I thought. But yeah, I don't know. I guess we'll figure that out as we continue to kind of move forward, which is a good thing for WFG, maybe not a good thing for GFI. But my question becomes, because a lot of the comments I get is, well, people want to follow leadership, and you can tell a great leader by the people that follow them, and blah, 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 blah. And it's like, okay, well, Eric was touting that he had 20,000 licensed agents, right? And so if 1,000 followed him, what's that, 5%? Was that 5%? So 5% followed him over to GFI, if we're assuming that it's 1,000 out of 20,000. So I don't know, maybe I was thinking that the actual 14,000, or at least a large part of them, would have been licensed agents, assuming he had 20,000. I wouldn't be surprised if 10,000 had followed him, or 5,000, but apparently it's only about 1,000. So I guess we'll find out more information as we continue, but I just wanted to share that with you guys so you have a perspective of, but this is what makes Eric a great leader, right? Is he's able to project the right things that make things look bigger than they really are. And so maybe it's 1,000 and it's not 14,000. So anyway, I hope you guys have a great one. Have a fantastic weekend. I know we ran long, but I appreciate you. And not exactly sure what's going to happen next Friday. I'll keep you guys updated, but we got some stuff going on Friday morning, so I don't know if I'll be able to be here. But anyway, we'll figure it out. I'll make sure I get whatever information happens this week out to you. And you have a fantastic weekend. You take care, and I'll see you later. Bye.